Thanks very much for that introduction. I'm delighted to have the opportunity to be here with you all today to debate this quite topical and I think increasingly relevant topic, and I'd like to thank Professor Morgera, who will hopefully arrive later, and the team at the Centre for agreeing to host it and arranging all the logistics. I think it's particularly important that we take the time to have these debates within the kind of academic and research focused setting, such as that provided by the Centre, to provide an independent analysis and critique, and hopefully bring that together with what's happening out in the field, very much at grassroots at the moment. It's also a particular privilege for me, as I remember well hearing from her as a guest speaker during my LLM in Stockholm on the topic then of corporate accountability. So it's quite nice to be able to switch roles, also with a bit of an expectation that many of you are likewise going to do the same in future. So I think just at the outset to say that despite the fact that I will mention some key challenges in this talk, I want to be clear that the landscape is far from bleak. Even after 12 years or so working in this field, I do still believe that we have the power to solve these challenges and that they are solvable, primarily in our generation. And as you will see, that is partly due to some of the incredibly brave, fearless and principled campaigners and lawyers who I have come into contact with and are literally taking significant risks every day to do this kind of public interest work. Often, as if not more important, however, are the cases which don't make the headlines and the ones that they are fighting to stop getting into court. So do take any cynicism that comes through in my presentation as more kind of food for thought for those of you who are going to go on to influential roles that shape the future direction of the playing field for our field and how we can approach things better. So a couple of quick lawyerly disclaimers to not break with tradition. Obviously, my comments are based entirely on my own professional experiences in my career to date, and I certainly by no means pretend to have all the answers to these complex challenges, but I hope that what I say and some of the insights into the journey that I have been on thus far, drawing particularly on the landscape of energy transition issues at grassroots level in Europe, provoke some quite interesting debate and dialogue about the challenges we are dealing with today to obviously make these improvements going forward. I think in my experience I would say that these challenges are such that there are often few binary solutions or simple winners and losers, and the topics that we're dealing with are also not always comms friendly. Journalists that I speak to will generally ask me, are what they're doing, is it illegal? And if you use that word, then you're guaranteed to get a story. So I'll come on to, obviously some of what I intend to share also, I have to say, is still topical and sensitive to a degree, so I may not be able to provide full commentary at this juncture for reasons of confidentiality, and some of the cases that I will refer to when we move forward into kind of Chatham House discussion, we can have a bit of a more free and frank exchange there. I think also in particular when I suggested this talk, Client Earth had not yet announced its intention to take the government back to court on its air quality plans. And whilst that's not one of the cases that I was personally responsible for overseeing, obviously I have had quite a bit of involvement in it, and so you'll understand we'll be cautious on commenting. Also, just kind of to mention, I've worked on a number of different sides of this coin, and one thing that I would say is, having worked in central government, local government, with environmental regulators in private practice, and increasingly with EU and international institutions, sometimes I find that that perspective leads me to disagree simultaneously with most of the parties to a case, and I think it's important to say that despite having a passion for the work, as a lawyer, sometimes that does mean that you need to tell your clients what the limitations of the law are. And I think as well, whilst it might be trite, in my view, the importance for dialogue and ongoing communication can never be overstated, particularly in a public interest setting. So also the job of a lawyer is sometimes bringing together and providing that kind of critical thinking perspective to advocacy and other efforts, almost like being a translator when working with technical and other experts. Campaigners, for example, you may find sometimes take a narrow focus on an issue, and it's really important always to take a step back and keep an eye on the bigger picture, which our training as lawyers helps us with. Another area just to mention briefly is the importance of transdisciplinary working, and that perspective can't be overstated. We really need to bring the law, science and policy together to create workable solutions. But overall, I think my experiences cement my view that we urgently need to be ready to embrace the complexity in the Anthropocene and develop legal structures which are capable of responding to complexity and both the known unknowns, but also the unknown unknowns, if we are going to be able to bend the curve to societies within planetary boundaries. And that's particularly so today, given that everything that you will come across is almost always now branded in some way as green. We know, I'm speaking probably to the converted here, that governments are failing to take generally the necessarily decisive action to respond to these multiple challenges. And so I fear that many of these matters will in due course land at the feet of our courts and judges. And I think that's something that we as a profession really need to consider if we're ready for. So I'm just going to kick off, and for those who have not heard, with a little bit about living law. I've got a couple of slides here which you can refer to. We're a public interest law firm established just 5 years ago. We specialise in environmental, energy and human rights law and policy, and our central mission is to uphold the rights of access to environmental information, public participation and environmental justice, so the 3 pillars of the Aarhus Convention, and also cemented by Principle 10 of Rio. We aim to advance, protect the right to a healthy environment for present and future generations, not forgetting obviously the greening considerably of the ECHR, which has taken place over the last few years, and in doing so try to play our part in helping to mend the relationship between people and the natural world through integrated solutions. We aim to deliver high quality legal services that don't cost the earth through innovation, basically trying to make advice accessible across society, which it's currently not. At the heart of all we do is a fundamental belief in equality before the law and in the power of the law as a tool for positive social change, touching on, as I've mentioned, this kind of critical perspective that lawyers can bring, and also advocating for a strong, diverse, independent and representative legal profession and judiciary to uphold the legitimacy of the law in societies. So it's impossible to talk about litigation in this field without also touching upon policy and political agendas which surround the debates. I'm not sure how much of you will know already from the course of your studies, but I'll talk a little bit about the different categories of litigation. Clearly, every case is not the same. Briefly run through some examples of why we might litigate, might not always be why you think, and then provide some case study examples from my work leading the EU Energy Transition Lawyers network across Europe. And then I'll finish with some general remarks and reflections, which are by no means exhaustive, about some of the key challenges of litigation. But before we get on to that, I want to introduce you to Shinobu Sakamoto from the town of Minamata in Japan, who I had the great privilege to hear from firsthand last month during COP1 of the Minamata Convention in Geneva. And I'd ask you to keep her story and her plea that we end pollution at the forefront of your mind as we go through today's seminar. Her story is one that I believe should be taught in every law school and university around the globe to prevent us from hopefully repeating the mistakes of the past. As some of you might already know, she was poisoned before she was even born from an entirely preventable and man-made disaster. And that's the burden that she carries every day as a sufferer of so-called Minamata disease due to the discharge of mercury into a river in Japan in the 1950s by Chiso Corporation, arguably one of the most significant environmental disasters. For her and other survivors, Minamata disease is not over. The disaster didn't distinguish between economic wealth of its victims. But I think it's quite important that if you have a quick person in the street test, it would suggest that most people today believe that this kind of tragedy is something which is confined entirely to the history books and simply couldn't now happen. It is, in my experience, largely assumed that governments fulfil their obligation to protect us from these kind of toxic exposures. Yet those of us working on these issues on the ground, and the case studies that I'll refer to later, even in Europe, demonstrate that this is just not the case. You only have to consider Dieselgate, or, as I have personally, stand next to coal plants in Bulgaria or Romania or Turkey, which discharge illegal levels of sulfur dioxide and other harmful pollutants like nitrogen dioxide onto local residents, or the illegal mines in Bulgaria which the governments say to you don't exist. The breaches of environmental law in Europe remain systemic and pervasive, but equally enforcement, we have to remember, is neither straightforward for the reasons that I'll come on to discuss, but they hopefully demonstrate some insight into why civil society do increasingly turn to litigation to remedy these failures. And I think these stories are also highly relevant in the Brexit UK, where the mood music is now definitely better, but we are still faced by a repeal bill which certainly threatens to take the heart from environmental protections and governance structures. Sometimes you might not appreciate the importance of sometimes quiet everyday work until it stops happening. And whilst I know that I'm likely preaching to the converted, let me say one thing very clearly for any politician who may in due course happen upon this talk. Environmental protections are not red tape, and they are not a bureaucracy or a leftist agenda. They're critical to each of our well-being and survival. So this is an infograph which I'm sure most, if not all of you, will be familiar with. It sits on my desk. It's what I refer to when assessing or launching any strategic cases, and it's why I included the SDGs in the title for today's talk. This isn't my vision, it's not your vision, it's a global vision that we've all signed up to. Getting there, of course, is another matter, but it's the reference point. The SDGs we know are all for one, if you like, and human rights are weaved throughout them all. I think it's quite interesting if you look at energy, for example, it's not just clean energy, it's also affordable energy that we need to be thinking about. There are still those who would argue the elements of this work and litigation cross the boundary into political matters. If you're working in this field, you will experience that for yourself. Yet we know that upholding and enforcing human rights and international law is a matter of the rule of law. I participated in the IUCN World Declaration on Environmental Law, and I strongly believe that the power of the rule of law can help us respond to these interlocking crises that we face at a global scale. But that doesn't mean that the task for judges is always necessarily straightforward, or one that I certainly envy. You can see there a picture of the Supreme Court. I think it's clear that we're going to need some quite brave judges as we go forward in this work. So getting into kind of substance of today's talk, there are different categories, obviously, of litigation. When we talk about environmental litigation in the Anthropocene, as I've mentioned, every case is not the same. There are numerous ways that you can kind of approach this case classification. I've given you there kind of 5 categories that I think are the main ones. Strategic litigation, where you're looking to push the boundaries, test new or novel areas of law, which can help others who may come behind you with similar cases in future, but you equally need to bring those with an awareness of the risk of losing or weakening a lever or argument that you may have in more kind of administrative work every day, such as, for example, the Climate Change Act in planning appeals. Reactive litigation, obviously what's happening in the US at the moment and the work that's going on there to try and prevent the dismantling of the EPA, and also successfully the UK work on cost rules. Quasi-litigation, so by that we mean administrative proceedings, public local inquiries, then more case-specific, such as Cardrilla and the fracking cases in Lancashire. And then one that I'll mention quite a bit, industry-driven interdicts against protesters, increasingly, SLAP suits, so that's strategic litigation against public participation, where the proponent may not have any intention of actually winning the case, but it is more just the bringing it and the kind of impact that that has on campaigners as a sort of chilling effect is quite a serious threat at the moment to democracy. So why litigate? Well, aside tongue-in-cheek from the 3 Fs of funding, fees and fame, which invariably do come into the equation, you're looking to create important precedents, test new or novel areas of law or the limitations, crucially open the space for wider policy debate, development of new laws such as that we're seeing with the New Clean Air Act in the UK, need to challenge though that this doesn't become a superficial exercise as politicians respond to the cases having been brought. Helping governments to manage powerful and sophisticated lobbying factions. Sometimes governments do want to make the change, but they're facing significant challenges in doing so. Once you have this credible threat of litigation record, also the fact that you may increasingly be able to head cases off before they ever reach the court door. And obviously journalists do cover cases quite well, as I mentioned, and so you have that significant media coverage and the significant leveraging of your debate in society. So I'll leave you to read these just from the interest of time, but just a few headline facts and figures in terms of globally the landscape at the moment. Fossil fuel subsidies is obviously a really interesting one that I've worked on quite a bit. A statistic there that 11 EU countries and the EU itself currently provide 112 billion euros in subsidies every year between 2014 and 2016 towards the production and consumption of fossil fuels. These are conservative figures due to hidden subsidies and a significant lack of transparency around some of these areas, but fantastic work that's going on at the moment by Overseas Development Institute and a researcher there called Sheila Whitley trying to provide that transparency. So you'll have seen this photo. An overjoyed, or rather I would say relieved, Cristina Figueres, who led the Paris Agreement to successful conclusion. And as we'll see, actually Paris is in many ways just the start of the real journey. But I'd like to caution also that, as the Brundtland Commission have told us since 1987, these are not separate crises. An environmental crisis, a development crisis, an energy crisis, in fact, they're all one. If you have the chance and you're interested in the energy agenda, I'd also recommend having a look in terms of background context at the report which has been produced by WWF, Can Europe and Sandbag, amongst others, to illustrate the transboundary impacts from coal in Europe in this case, highlighting also that these are not just decisions for sovereign governments, and in fact is interesting from a legal perspective in terms of where we might think the restrictions and limitations on sovereignty actually rest. This report and the work on transparency around it have demonstrated systemic failures across the board, with, I'd say, the majority of countries in the same position, with plant operating out with legal parameters and significant defects in public participation in decision making, such as in permit reviews, contrary to the Aarhus Convention. But it's not all doom and gloom. We're increasingly moving towards this landscape with governments announcing coal phase-outs, as you can see from the map. And I would seriously question whether this degree of progress would have happened without litigation and advocacy work simultaneously from NGOs such as EEB and Can Europe. So obviously I can't go through today every EU country that I've worked in, but I'll talk in a little bit more detail about my work for Client Earth in the UK, Bulgaria and Turkey, which we had classed sort of along with the EU for these purposes prior to the military coup, highlighting some of the gaps between law and policy at grassroots level, and also between what government is saying on one hand and why you might still need to come in with litigation on the other. So starting close to home, the UK, there's a nice photo shot there of the Minister reaffirming the UK's commitment to phase out coal by 2025 during a recent bilateral with Canada. And also now we have a clean growth strategy for the UK, which includes the principle of efficiency first in energy policy. This is a significant development, one that we've campaigned for a significant number of years to see. Particularly interesting is, for example, SSE would give you the statistic that 1/4 of all Scotland's energy is used by items which are on standby. So you might think, seeing this nice photo and that what I've just said, that there's no need for litigation, but of course we'd argue that that's not correct. Actually, it still remains very much to be seen how the UK government will actually legally deliver the coal phase out. If we're trying to limit the scope for future litigation, I think that we do need to really seriously consider that. And I have argued for some time that we do need primary legislation to deliver a meaningful phase out in the UK. But with Brexit ongoing, it's challenging to say the least for the government to secure the parliamentary time that it will need if it had the will to do that, and I suspect it may not. So are we storing up litigation for the future if operators decide in 2023 or 25 that they have another plan in mind? So there's some cases that are referred to there that I've worked around the UK on, particularly the IED, Industrial Emissions Directive. There was an optional derogation which the UK didn't have to, but decided to go for, which is effectively like a reducing bubble of emissions year on year. The plan had serious irregularities in it and wasn't approved by the European Commission until the very 11th hour, something that we lobbied DG Environment on substantively. There was almost no public participation in the process, and thereafter the UK Parliament and House of Lords actually held that the regulations which were brought forward to implement the TNP in the UK were potentially unlawful because they'd been laid before Parliament prior to the Commission's approval of the plan. These cases didn't end up in court, but they demonstrate the power of just a well-timed letter to clerks, knowing what you're needing to argue. Another example of kind of out-of-court wins using a litigation approach, this is a piece that we did with the Financial Times and Patilla Clark. So on the one hand, you had the UK government saying that it's going to phase out coal, but then simultaneously lobbying behind the scenes across Europe, trying to garner support from Poland and other countries in sort of the Visegrad, as it's termed, to support this delay of the large combustion plant BREF, which sets the standards for best available techniques that will in due course be applied to these plants and the permit reviews. And if that had happened, it would have had serious public health and environmental consequences right across Europe. But as I all acknowledged when you can come back and read the previous slide, these aren't straightforward issues. If we push operators too hard, they may actually withdraw from the market earlier than is currently wanted, leaving to disorderly transition, or make investments in upgrades which they then seek to extend the life of the plant and recover. I'm going to skip over this, but it's an interesting case study of Longannet in Scotland, a Scottish super polluter. Scotland itself is now coal-free already. This is a blog that Bartosz Krupa, one of my former interns, wrote for me, and I think it's quite interesting in terms of a running saga of litigation against a plant which had been held by court to be in violation of EU law, and that went on for 7 years because of the lack of a technical solution. So moving on to Bulgaria, just to give you a bit of insights into the landscape there. Just as an illustration of the importance of just transition, and secondly, just how bad the enforcement deficit is in certain parts of Europe actually on the ground. In these cases, usually we generally find that it's never too far from systemic corruption and oligarchs, unfortunately. The picture that you can see there is just taken on my iPhone, and even with that not fantastic camera, you can see the toxic soup of pollution which is sitting on the town of Sofia, the capital of Bulgaria. Much of that's caused by traffic pollution, often from older cars which have been exported from Germany and other such countries at the end of their life cycle, and also from district heating. But coal plants definitely do feature in the causes. I'm just going to try and show you this quick clip. So this is one of the coal plants which operates in Pernick. There are, you can see how close that is to residential areas, unlike in the UK where these sorts of plant are out with towns and cities. And another one where the plant actually, I visited this plant and I thought maybe it employs a couple of hundred people. There are 3,000 people whose jobs depend on this one coal plant, and there is literally nothing else in that area. In the past, they've tried to bring in, for example, a glass factory, but as soon as European funding dried up, the factory also then moved out of the area. And I think this is one of the areas where I've really pushed for us to focus on the issues of just transition. Can't really just take an eco-imperialistic approach of just close it down. In this case, I spoke to one of the local mayors who was probably taking quite a significant risk in speaking to us, and his message was that they wanted clean up, not closure. So protectionism, I think we'll talk a little bit about the risks of litigation. This article, which you can come back to and read, I think is a good example of this risk of one step forward, two back. Shortly after launching projects in Bulgaria, the government there announced its intention to restrict access to justice, contrary again to the Aarhus Convention and existing even findings of non-compliance by the Compliance Committee, which may in due course require to be separately litigated against. So you need to begin these cases having an awareness of this risk of one step forward, two back, and you need to be planning for those kind of eventualities. And then just as a final kind of case study of some of the work that I've been doing, just obviously Turkey is a very challenging context at the moment. However, when I was doing this work, it was prior to or just around the time of a military coup, and I was really considering supporting ECHR work there as strategic litigation because Turkey is party to the European Convention on Human Rights, but some of the issues evidentiary are extremely poor, and so makes bringing a case relatively straightforward in some ways. The Turkish government, however, then announced its intention to bring forward this new super law, which we refer to as Article 90, and it would have allowed it to grant approval to projects which it deemed in its own volition as strategic investments, and thereby disapply environmental impact assessments, which, whilst not perfectly harmonised with EU law, were moving forward as part of the prior accession negotiations. That case is being challenged in court by CHP, the opposition political party, as the only party withstanding under national law to bring the claim. And we sought to lodge an amicus curiae brief with the Constitutional Court in Ankara in partnership with Greenpeace. But sadly, Turkey is not alone in these views, often of energy projects as being nationally significant. But they are one country where there are significant plans still for new coal plant, notwithstanding the fact that they are party to the Paris Agreement. And interestingly, in those cases are being financed from the Chinese government. So the levers that you might have around banking and things might not be there. Just one case in Turkey to mention also is the Yurca village case, which I think is extremely interesting. One thing that's happening in Turkey is that there are significant amounts of compulsory acquisition of land which are proceeding using effectively wartime powers which are not intended for this purpose. In this case, 6,000 olive trees were cleared from villagers' land without the legal processes being complied with. I would ask you how you would feel if you came home one day to a notice on your land saying that the government had acquired it. Generally, these groups would not have been able to access the level of advice that they would have needed to be able to respond to that kind of pressure. But fortunately, Greenpeace has, I would say, a real-life Erin Brockovich, Deniz Bayram. She stayed for several weeks in this village campaigning on the land to guard the trees and help local people, and fighting the gendarmes, the police who were there to remove the villagers. I think it's quite an interesting insight into the real, frontline reality sometimes of public interest work. but also a slight bittersweet victory, because in this case, the court upheld Greenpeace's complaint, but there was no option to seek interdict beforehand, and so the damage that's being done to villagers' land will take several years to be undone. So again, interesting insight to sometimes limitations of litigation. And just an example recently, which is from the media, about the risks sometimes for environmental defenders. This recent Guardian article here gives the example of an elderly couple who allegedly have been murdered for opposing a gold mining development which was planned beside their home. These kind of signs are unfortunately all too common, and one which the United Nations acknowledge we need to do much more to protect environmental defenders and lawyers who are working on these issues. So, literally there are now hundreds of cases that I could have talked about on climate litigation. It's a hugely growing field, from the Arctic drilling cases against the Norwegian government using constitutional law, to the Swedish children who are suing the Swedish government over Vattenfall's divestments in Germany. One thing I would say in terms of litigation, I think this picture sums it up neatly. Sometimes it is a bit of a case of throwing the stone into the pond. You don't always know exactly where the ripples are going to go. And again, just kind of snapshot of what I think some of the challenges and limitations are. Firstly, eco-imperialism, taking the examples that I gave from Bulgaria. Are you just fueling Trump syndrome, or kind of the Brexit? We need to be bringing in the just transition debate and the simultaneously trying to advocate for solutions. Also thinking about who is it that's coming in behind potentially to make investments in these countries. Practical, evidentiary, so you've got your carbon majors concept, but also things like the volume of disclosures that you're going to face in dealing. Very often a significant tactic is just to bury the other side in lots of documents. They're not going to find necessarily what they're looking for. Is it genuinely public interest? Who really wins? It might not always be who you immediately anticipate. And is it just tactical? Delay, or passing the buck for the difficult decision? I think in my experience you will find that very often government might be quite happy for you to litigate. Are you just playing into that, their hands, if you like? And then the financial, so market impacts, that's where often the change is happening, and the impacts are often felt aside of, or as well as the judgment. I think that's quite an interesting thing in terms of the Trump and not being able to roll back some of the work that's been done there on clean energy. And then coming on to remedies. Currently, you might find that the remedies that you can actually seek from the court are weak or of limited enforceability. And so this is a bit of a double-edged sword as well. Do you risk actually undermining the rule of law? We've talked about one step forward, two back. Judicial culture, I will mention, is very important. I think my experience from working across Europe is that one size definitely doesn't fit all. There is a huge difference between adversarial and inquisitorial systems. In Bulgaria, for example, the breaches may be systemic, but actually the judges are quite happy to appoint an independent court expert who will really try to drill down into some of the detail and to take that on board. Obviously cost in the UK, even with protective expenses orders, protective costs orders, SLAP suits as we've mentioned, campaigner safety. And then coming down to, I talked about a little bit earlier about lawyers always having to differentiate their position from campaigners, and remember that you have to uphold your ethical duties to the court first and foremost. So I'm not going to go through this in the interest of time, but just I think an interesting case about the UK judicial culture. I'd recommend reading the Inner House judgment in the RSPB case if it's not one that you've already come across in your studies. I think it's one that's particularly disappointing, where the second instance court effectively showed a very high degree of disinterest in the issue overall. And in terms of SLAP suits, just to give you a bit more of a kind of insight to these. One that's quite interesting to look at is Resolute Forest Products against Greenpeace International. Now, this is a multi-million-dollar lawsuit which was filed against Greenpeace using laws that were originally designed to effectively regulate mafia. Its value was $300 million US. Thankfully, in this case, the judge has dismissed it and held quite clearly that the defendant's speech constituted the expression of opinion or a different viewpoint that are a vital part of our democracy, noting also that Greenpeace's publications about this company, Resolute Forests, relied on scientific research and fact. But if you click on this link, you will go to the court, the documents that are listed on the court's website, and you will get some kind of insight into the volumes of disclosures that you're dealing with, how much time and effort and the chilling effect that can actually have, just kind of defending these quite sinister complaints which really had no or very little prospect of success from the word go. Okay. So just kind of finally quickly touching on reflections, I think litigation increasingly is an answer. I would say that it's debatable if it ever provides the optimal one. It's far more challenging to develop workable solutions to key environmental challenges which take a holistic view. I think litigation should rarely be viewed as a panacea or as a tool of first resort, and I think that its presentation as such is both irresponsible, opportunistic, and overstates the power of the law in isolation. I would say that taking a case into court does carry a certain sense of failure for the lawyers involved. It doesn't mean that you won't proceed, but I think that's the correct approach because it is generally a blunt tool. We've mentioned about remedies, the retrospective nature after the event, the timescales involved, the fact that sometimes you will have suboptimal outcomes, and the risks of looking at one environmental issue in isolation from others, as the SDGs would suggest we should be doing. But these cases, whilst they're often practically difficult to bring, they are increasingly happening, and governments should be under no illusion that more are definitely coming. But also public participation is key. I've mentioned a lot about the Aarhus Convention. It's a central plank of the work that I do, but I would also question, is it right that civil society are left to fight these kind of David and Goliath battles given the power of the corporations which are involved? Looking forward, I think we need to also better manage the scope for abusive litigation, attempts to pass responsibility for difficult decisions to the law. I think there's some, it's quite cynically, politicians who would be quite happy for courts to take the decisions that really they ought to be. And we've touched on judicial culture. I think it's unquestionably the case that certain parts of the UK judiciary are entirely nervous about adjudicating these cases. And the cases that you're dealing with, you may find increasingly they challenge existing jurisprudential thinking. So do they have the tools that they need, the specialisation and the training, and are we ready for what's coming? Particularly also, as I mentioned, because the economic consequences of these cases may be increasingly extremely high, which invariably creates its own practical challenges, and I don't think that that's going to change. So overall, governments, I think, will have to accept that their failures to sufficiently drive change may now lead to case outcomes that are sometimes suboptimal in policy terms. Their response is then it's open to them to put legislation before Parliament in order to remedy that. So the wider European constitutional landscape when you're talking about energy is also something to bear in mind. Are those kinds of cases with such significant financial impact, are they exacerbating it? Particularly as energy security is equated in many countries still with national security, notwithstanding what the Aarhus Convention states. And it is seriously challenging to civil society. There is a significant closing of space. I know that many of the campaigners who I've worked directly with have been monitored by security services. Contrary to international law, we know that that's happening. And the one step forward, two back risks of pushing too hard. But just to bear in mind that this is not usually overt, it will be things like the Lobbying Act in the UK and the chilling regulatory requirements of that, extra scrutiny of tax returns and those sorts of things. But one area where I think that we could do so much more is definitely on the scope to litigate about transparency. I think there's a really interesting case which is being brought by Matrix Chambers. Obviously it's on Brexit, but about the sort of secret studies about the impacts of Brexit. there, in the litigation context in England and Wales, you might then interestingly find that the duty of candour is applied then personally to the government lawyers that are involved. So it's a much stronger tool in many cases than just pure freedom of information requests. These rule of law challenges that I've talked about a little bit, they're coming, and I think the ultimate bottom line is that urgently as a legal profession we need to advance our thinking on remedies. I think mediation is definitely a very interesting potential growth area for the future, but also increasingly fast tracking of case hearings so that there isn't this kind of ping pong going on and a bit of a mockery being made of our courts. But alongside asking for the courts to make changes, we also need to make asks from policymakers, firstly to grasp the urgency and understand the potential conflicts which are arising. Overall, I think there's a general need to update and design environmental law to be far more flexible and capable of responding to unforeseen eventualities, to embrace complexity, resilience thinking, and the unknowns of the Anthropocene. And then this is particularly so around the nexus between energy, water, and biodiversity, also upholding Indigenous rights. But also, can we really win or tackle effectively some of these issues without also simultaneously really addressing corporate power? I mean, it is the case, as I have seen, that many countries are almost being held hostage by some energy countries and things to try and lock them into particular agendas. You only need to look at the payments that companies in the UK are receiving under the capacity payments to keep power plants on standby. So that when everybody puts their kettle on at 7 p.m. in the evening, the grid is able to withstand that. And there are obviously discussions which have just launched this week about the need for a binding treaty on human rights. So just quickly, a little bit of audience participation. I don't know, can anybody read that tweet from the New Economics Foundation at the bottom there? So it says, why big money doesn't want a diesel ban. So I would just ask if anybody has any ideas why big money might not want a diesel ban. Not Erica, because she already knows the answer to this. Any volunteers? I'm just going to pick somebody. Not to be put on the spot. You don't have to get the right answer. There isn't a prize. What else? How is every car that's ever been purchased generally financed? Exactly. So I think that's quite interesting in terms of when a court is looking at some of these issues and what the consequences of judgment might be in terms of market impacts. So questionable, have we really learnt the impacts of the last financial crisis? And a fantastic author, I think I'd recommend if you have the time to look at this book by Kate Raworth. She's previously a researcher for Oxfam, and basically her idea is about how you bring together planetary boundaries and the social element in terms of operating within the safe operating space, as is shown there, and increasingly gaining traction. So just very briefly, this is a picture here of the IUCN World Declaration on Environmental Rule of Law. I have a whole seminar specifically on this. Two concepts that I would mention: in dubio pro natura, so where in doubt nature prevails, idea that this builds on the precautionary principle, and then the idea of non-regression, so that we can't have what's happening in the US with Trump. We can't continually be going one step forward and two steps back all the time. I think that these two concepts, the mantle has been taken up, and Eric Solheim from the United Nations is driving this. It's been given significant backing from President Macron, who I think intends to place it before the UN later this year. Those two key concepts, and there may be an opportunity in the UK as part of the repeal bill to consider whether those kind of concepts could be brought into our national law. But I think that they might help judges, to manage some of these conflicts and trade-offs. And then just two final thoughts. So Aarhus Convention, a bit of a declaration which came out of the recent MOP meeting of the parties to the convention in Montenegro earlier this year. The declaration states, we acknowledge that these challenges can't be met by any one actor alone. The effective engagement of civil society, keyword including NGOs, academia and other stakeholders, greatly reinforces and complements the ability of governments to address these problems. Such stakeholders also play a key role in holding governments to account, and then noting also the point in emphasis below where actions needed from all stakeholders, including also innovative science community and the private sector, and that we need to be using that to the fullest extent. And I would suggest that if governments want to try and avoid some of these kind of conflicts and litigation cases, the best possible way to do that is actually through far better use of strategic environmental assessment and planning, because that brings in public participation, and they generally don't do it well because they don't want to hear those difficult issues at the outset, but they're going to come either way. So I think, you know, we could have seen that if we'd undertaken, for example, proper spatial planning about the siting of renewable energy developments, for example, that people like RSPB would have brought in their comments to try and guide them away from sensitive areas so that developers aren't investing significant amounts of money and resource in sites which then, you know, in due course become quite problematic for them. So that's a huge amount to get through in the time available, but I think it's important to take a macro view. Sometimes, obviously, it goes without saying, litigation can be both friend and foe, and I'm quite interested to hear your reflections, questions and debate.